So I'm Alana. I deal with your estates basically once you've passed away. So we read your will and have a look and see what's going to happen. There's a misconception about reading of a will. So you've seen American movies and everyone goes to the lawyer's office and they're all sitting down with the will. That doesn't happen. We sit down with the executors, we talk about the will, we find out what the estate consists of, and we have a chat about implementing it. So the first thing we normally do is when we're contacted is we have a chat to the executor about what the first steps they need to do is. So it's notifying everybody that somebody has passed. It's notifying all the family members that need to be told. It's making arrangements with your funeral directors if arrangements are not already in place. It's notifying work and income that somebody has passed so that any benefits can stop. Your benefits will continue to be paid for 2 weeks after you've passed, and then after that they should be stopping. It's contacting the bank, it's insurance companies, who needs to be told that somebody has passed away. So we have a chat and work out what has to happen there. So first steps obviously is sort of covering off the funeral arrangements. And then we have a chat about what the estate consists of. So what some people like to do is to have a clear file at home where they've put everything in it. So they'll have at least one bank statement in there. There'll be an insurance document or something. There might be a list of, I have houses here, here and here, or this is where I keep all my assets. It's really helpful to the executors to know where your assets are because they don't always know. So you're having information where all the assets are is really helpful to your executors because sometimes they don't know, especially if they're not particularly close family members, if it's a friend or something like that. We then have a look at the will to see what we're going to be doing. So we have an idea where it's all going down to the children, or if we've got life interests, what that's going to look like. And we talk to the executors about what's got to happen, what assets need to be called in, and how it's all going to work through. So with bank accounts, what's really important is making sure that the bank accounts are going to be secure while that probate is being obtained. So probate's when we file your will with the High Court and get the permission to be able to deal with your estate. So we always ask that all the EFTPOS cards and debit cards and things are kept in a safe place, especially with PayWave and things like that. It's quite easy to continue using it. The bank will not freeze the bank account until they're notified that somebody has passed. When the account is frozen, all direct debits and automatic payments will stop, but money can continue to go into the bank account. The bank will then tell us what their requirements are for closure of the account. Generally, every bank will require probate if the balance is $15,000 or more on the date that the person has passed away. So even if you have your balance is $15,300, for instance, the bank will often say, yep, we require probate to deal with that. Unfortunately, it's a very old, a very small amount, but it's based on very old legislation when people had a lot less assets. And joint accounts, they will pass to the survivor person. So probate. Probate is the court order confirming that the will is valid and that the executor named in the will has authority to act on behalf of the deceased person. The executors are responsible for administering the estate and distributing it in accordance with the instructions of the will. As Jamie said before, that's someone that you're going to want to trust that can look after things when you're no longer here to be able to deal with them. So it's someone that's hopefully a bit savvy, knows, how to do things. But of course, we're there to help them along. We explain to them what the process is and what they need to be doing. So we try and make it as easy as possible for your executors.
Alana, with the probate, with the validity of the will, just a little explanation on home kept wills and staples and tampering, eh?
Yep. So the court likes to make sure that they're dealing with the only original will in existence, and it's the last will of the person. So the court actually goes through your will with a fine-tooth comb. They're looking to make sure things like staples haven't been removed from it, because there could have been another bit of paper that had additional instructions that may be missing from what the court's seeing. They're checking signatures to make sure the signatures look like true signatures. They're making sure that all the pages have been witnessed appropriately, so there's correct initials on every page. They're basically making sure that that document has been executed as a true will, and that that's the document you need. When people pull staples out, or they put paper clips on wills, or anything that damages the will, it can create issues when you're going through the probate process. And requires extra evidence to be given by people that witnessed the will when the will was signed. So we always recommend that you generally, if you can, get us to hold the will so that we can make sure that it's not obviously going to be damaged. We keep it in our deeds registry, and it sits there until it's required. And we check it for things like staples removed and stuff like that, and then we can keep notes that we hold as evidence to file with the court if we need to. So probate's required when there is any singularly held asset worth more than $15,000. So that's a bank account. If it's got more than $15,000, you're going to require probate. KiwiSaver accounts, life insurance policies, you've got your house, any shares in companies, and we will need it also when we're dealing with complex estates and things. So if there's going to be claims and stuff, you need probate to be able to deal with those as well. So we know we're dealing with the correct people to make those decisions on behalf of the deceased person. What happens if you die without a will? It's messy. It's the law provides us with the Administration Act, which sets out who has a hierarchy of applying for what's called letters of administration. Letters of administration is the document that gives you the ability to be able to deal with someone's estate. There's rules on who can apply. So the first person with priority is the deceased's spouse or partner. If there is no spouse or partner, it passes equally to the children of the deceased that are 18 years or older. So if you've got more than one child, all of the children can apply, or one or two of the children can apply, but the other children need to consent to that application. If there's no children, there's another list, and basically there's a whole set of different examples where it branches into further family members. Ultimately, if you don't have any family, it's the Crown that applies to administer your estate, or the creditors of your estate, so that's someone you owe money to. How is the estate distributed? So the law provides that the first $155,000 of your estate goes to your spouse or partner, and then after that the balance is split between the spouse and partner and the children. So the children then receive 2/3 and the partner or spouse receives 1/3. That's how it is. That might not be what you want, which is why we want people to have wills so that we can avoid dealing with estates where the split's not what you want it to be ultimately. And it also means that your assets aren't going to go where you want them to go. So you might have said, I want you to have this to a family member, but that's not going to happen necessarily. They're going to have to go through a testamentary promises claim, like what Jamie said, or a family protection claim, and it gets messy. Letters of administration is not a fun thing for family members to necessarily have to deal with. How long does an estate take? How long does it take? Depends on your assets. It depends on so many things. To apply for probate at the moment in the court, it's taking roughly 3 or 4 weeks after we have filed the application to get probate, which is the document that allows you to start administering the estate. Hold on, I've skipped ahead. Sorry, I have. Okay, immediate steps. First few weeks, these are your priorities. Notifying the family and arranging the funeral, finding a will and locating it. So if somebody passes away, we're not sure that they have a will, we can actually search with the Law Society and also with all the lawyers in New Zealand for a will. Everyone checks their records. That can take a while, obviously, because there's so many thousands of lawyers. So we recommend about 3 weeks for that sort of time frame. But if your will is with your lawyer and you know where it is, you don't have to advertise for a will if you're all certain that's the most recent last will. So how long does it take? So applying for probate, 1 to 3 months. So the processing times are about 3 to 4 weeks for probate or letters of for probate. If there is no will, the process is much longer. So we have to advertise for a will. We then have to do certain searches with the Department of Internal Affairs in regards to children of the deceased. That can take quite a long time, so it can be quite a few months before we can get a grant of letters of administration if you die without a will. Delays can occur with the court sometimes if they've got a backlog in processing of applications. So during COVID, we were waiting in some instances 16 weeks to get your documents back from the court. That's come back down again now when we're back at around the 3 or 4 weeks, which is much better.
Christmas is another time that
Yes.
you get caught.
Yes, because the courts do shut over the Christmas period, as do law firms. And so generally, there's an extra 2 or 3 weeks you have to deal with there while the court's shut. General administration of the estate. So depending on your estate, it can take anywhere from straightforward 3 months to 12 months to sort it out. It's going to depend on how easy it is to gather in all your assets. So if we're dealing with New Zealand assets, it's relatively quick, but if we're dealing with shares in Australia and things like that, it can be quite a slow process. And especially when you're dealing with the UK as well and other bigger international centres, because they require original documents, and so we have to post and courier everything over, and of course that takes a lot longer. So the things that happen are the paying of the debts and ensuring all the tax obligations are met and all the financial accounting and distribution is done. So the timeframes for that are quite unknown. We try and act as fast as the executors will tell us they want to do things. The most common time frame for people to make claims on estates is in the first 6 months of probate being granted. So we always recommend executors do not distribute estates for the first 6 months, because that's obviously the time people are going to be sort of getting their advice from their lawyers if they want to challenge estates and things like that. As an executor, you can become personally liable if you are distributing an estate and a claim is made. So that's why we tell people to wait 6 months. It can also sometimes take that long to collect in all the assets and things anyway. Selling houses and things like that, that's not always a very quick process. So the executor is going to collect everything in, they're going to pay all your debts out, and they're going to do any final tax returns with the IRD. That again takes time, and there's certain time periods where you can file those returns. But we can look to do things like interim distributions and things like that if family members are in particular need of funds. So basically, having everything as together as you can is really helpful for your executors. Like I say, a clear file or a book, or if you prefer to have everything online, a folder in your computer which says where everything is, where all your assets are held. Making sure that if you can pass it on to your lawyer or to the executor in advance of your passing if possible. And making sure that you keep all your contact details for your executors and beneficiaries in that list as well can be very helpful, especially if you've got people overseas. How are we going to contact them? How are your executors going to find them if they don't know who they are? And just stressing the importance of having a will. As I've sort of covered, letters of administration is not an easy thing to navigate through, especially in terms of how your assets are going to be distributed. So yeah, making sure that you've got your will in place, which says where you want your assets to go, is really important.